Greetings, family. This is Davon Love, Director of Public Policy, Leaders of a Beautiful Struggle. This is our installment of Streets to the Statehouse. Really appreciate all of you that continue to watch this podcast. The really purpose of this is to keep people up to date on some of the work that we're engaged in the Maryland General Assembly. I want to reiterate, LBS, Leaders of a Beautiful Struggle, grassroots political think tank, explicitly Pan-African, revolutionary Pan-African nationalist perspective, which is a very unique perspective as it relates to being able to influence the policymaking arena on the state level. And so, what we've been talking about over the past few podcasts, we've focused a lot on juvenile justice reform. As folks who may be familiar, it was a major part of our legislative agenda coming into the 2024 General Assembly, which is to protect the progress that has been made on juvenile justice, particularly in 2022, the Juvenile Justice Reform Act, which limited the capacity to incarcerate, children 10, 11, 12. And then in addition, the Child Interrogation Protection Act, those were two pieces of legislation, core pieces of legislation that represent progress as related to juvenile justice. And so we focused a lot on that in the past few episodes of Streets to the Statehouse. I'm going to start by talking some about that, but I'm also going to transition to talking about some of the other aspects of our legislative agenda that have been kind of a lesser priority, but are important for folks to know about. And so just to put a bow on some of the stuff we've been talking about as it relates to the work on protecting the progress that's been made over the past couple of years, as it relates to juvenile justice, racial justice now, Leaders of a Beautiful Struggle, and other organizations, ACLU of Maryland. There's going to be a press conference tomorrow, Thursday, the 14th, 1:30 at Lawyers Mall. So that's an opportunity to hear about in more detail our reflection and the reflections of other advocates on the juvenile justice bill that has passed both chambers, has passed in different versions. And so the work for the legislature will be to go to conference committee to determine ultimately what the finished product will be. We have been very insistent on referring to it as the Fox 45 bill. One of the things that LBS has been talking about pretty consistently at this point is that the conservative right-wing Sinclair Broadcasting Fox 45 network has practically acted as an advocacy organization that has pressured Democratic Party leadership to pull forward a bill. One of the things I think is important to note is that while the bill as introduced has been weakened significantly as it relates to the current posture it's in both chambers, right? It's still important to note that it is a bad precedent to allow this kind of right-wing conservative news agency that is acting as an advocacy organization to have this much power over the legislative process. And even in my own private conversations with members of the Maryland General Assembly, there was kind of a general understanding that the media environment created a chilling effect on advancing the work on juvenile justice. And so that's a big part of when you look at our legislative agenda, it focused a lot on trying to just protect the progress that's been made because we anticipated that there would be legislative attempts to roll back. And what we see in the bill that exists now expands the jurisdiction of Department of Juvenile Services in a way that exposes more young people than necessary to the criminal justice system. And I want to reiterate, I was fortunate enough to visit the Church of Empowerment Temple this past weekend. Pastor Robert Turner, by the invitation of Sister Linda Lewis, who invited me and Sister Keisha Wallace to address their liberation ministry about some of the work that was happening around juvenile justice. And so one of the things that I made it a point to emphasize to that audience, and I want to make sure to reiterate, is that what's on the table is not whether or not young people that commit violent, heinous acts should be held accountable. And unfortunately, the media narrative has constructed a context where that's what people think the conversation's about. None of us that are advocating for protecting the progress that's been made on juvenile justice and advancing the work, none of us believe that young people should not be held accountable for engaging in violent, criminal, heinous acts. And in fact, the law as it existed prior to the bill that is before the legislature changes that young people still were able to be prosecuted for engaging in violent crime. That didn't change. But unfortunately, the media narrative has constructed an environment where people think that is what's on the table. And so it's important to raise that, because the challenge is, and one of the things I also want to emphasize is that as a person who's done legislative advocacy for many years, particularly on these issues, in many ways, this is the most that I've heard conversation about the importance in investing in young people that I've ever heard. I think there's a recognition that a incarceration-centric approach to dealing with young people is not effective. But unfortunately, we have an environment where people want quick, short-term solutions to problems that are really long-standing, that there's been a kind of societal disinvestment, along with the profiteering on the suffering of Black people. And so many of the services that are provided are dysfunctional. There has been, you look at the Hogan administration, the way that juvenile services was hollowed out in terms of its capacity to really give strong, effective community-based services. And so that environment created a context where we're dealing with young people. Incarceration is the most available option. And so we are disappointed with the fact that Fox 45 has been allowed by the Democratic Party leadership, who presumably would be on the other side, have been forced into a position where they're passing legislation essentially to appease the advocacy of Sinclair Broadcasting and their right-wing agenda. Again, you'll hear more about that tomorrow during the press conference. And so we'll talk more about that tomorrow, but just wanted to provide that as a general update in terms of where we are. The press conference will be to urge the governor, who's a part of Democratic Party leadership, who advanced this bill, to urge the governor to veto the bill, again, as a sign that Fox 45 shouldn't be a lead element in the legislative advocacy or the policy making in our state legislature. So that's the juvenile justice, where we are now. I want to use that to transition, though, to kind of a much broader conversation around the legislature, and that'll actually empty into some of the other aspects of our legislative agenda that we haven't been able to talk that much about over the course of the past several weeks during the Maryland General Assembly. I want to start with the fact that we have to understand the attacks on juvenile justice in the larger context of the political and ideological terrain in the Maryland General Assembly. There was a time when law enforcement prosecutors controlled criminal justice policy in the state, that to the extent that we were able to get small victories, right, was significant given the amount of control that folks like Scott Schellenberger, the state's attorney from Baltimore County, you have Rich Gibson, who's the current chair or president of the Maryland State's Attorneys Association. You have the Fraternal Order of Police. These are entities that, again, in the past, dominated the policymaking that came out of both committees. And one of the things that you've heard me talk about in this podcast is that when you look at, for instance, 2021, the repeal of the Maryland Law Enforcement Officer Bill of Rights, you look at the Anton's Law, which was a change to the Maryland Public Information Act that allows for investigatory records of law enforcement to be disclosed at a discretionary basis, depending on those records. Whether it is the use of force policy that provides some kind of guardrails in terms of police officers' use of force, whether we're looking at the legalization of recreational cannabis, right, which is something that law enforcement opposed, and particularly when you look at legislation that we worked on with other organizations, ACLU of Maryland and others, around ensuring that law enforcement could not solely use odor as a basis for stops and searches, given the fact that cannabis is a legal substance, and the opposition of prosecutors and law enforcement. Whether you look at the Juvenile Justice Reform Council, as I mentioned before, and the Child Interrogation Protection Act, this demonstrates a shift away from the absolute power that the law enforcement establishment has had over the committees that are responsible for making criminal justice policy in the Statehouse. And I would argue, as I've argued in the past on this podcast, that the attacks on the juvenile justice system, because young people, the crimes committed by young people only make up 10% of overall crime in the state of Maryland. So the focus on it was clearly a political and strategic one, that what we're seeing is a political backlash. Pair that with the fact that you will hear many legislators. I wrote about it in a op-ed that I wrote for Maryland Matters about a year or so ago, where I talk about former Senator Bobby Zirkin, former Senator Michael Huff, and others describing the legislature as going too progressive, going too far to the left. So all these things overlap with the way that the legislature, because law enforcement and the law enforcement establishment doesn't have the kind of absolute power that it used to have over these two committees. What has happened is that this is being described as some major left-wing turn in the legislature. And that is important because I would argue that the political ideological scales were pushed so far to the right that even a small but meaningful move, right, towards the left, away from the hard right-wing agenda, is experienced by the law enforcement establishment and those who were more conservative as a massive shift in the ideological terrain. We would argue that, in fact, these small but meaningful shifts that, organizations like LBS and many others for years have been pushing the legislature to move further to the left, where the needs of the community have demonstrated a need for policies that are more in line with addressing the concerns of working class Black people. One of the things that we're seeing, even in that small shift, again, is a recognition of the loss of absolute power from the law enforcement establishment. And so from our perspective, we would argue that the legislature is still way too far to the right in terms of its policymaking. And I'm leading with that because that some of the other things on our legislative agenda, which haven't been as prioritized, I would argue these are things that should be no-brainers. Things that if the legislature was truly this progressive bastion that the law enforcement establishment and other conservative political forces claims that it is, but the things that I'm about to mention would be no-brainers. And so I'm saying this to say that that we have to be clear that even though we've made progress, I mentioned on the juvenile justice piece that many organizations were able to weaken the juvenile justice bill so that it would be less damaging than how it came in. So it's important for us to recognize the power that we are able to exercise against that tendency, against that circumstance. But it's also important for us to keep in mind that even though we have significant power and we have increased our ability to impact the legislative process, that the legislature, in terms of its political terrain, is still one that represents the status quo more than anything that is liberatory or pursuing justice, and that there's a lot of work to be done, and that we can measure the extent to which progress has been made by whether or not the kinds of policies like the ones that I'm about to lay out are easier to pass. That, again, these should be no-brainers. And in a place where that becomes the norm, then we can say that we've made significant progress. One of the way that I'll put it, it's a quote that I use a lot from Malcolm X: you don't put a knife in a person's back 9 inches, pull it out 3 and say you've made progress. You have to pull it out, getting the heel before you say progress has been made. That is our standard when it comes to the ideological terrain of the Maryland General Assembly. But the knife's been pulled out a few inches, right? But we're not going to say that we've truly made progress until we're able to have more generative policies that are truly investments in Black people's ability to practice freedom. Until we're there, right, we should not celebrate any progress that we see. But again, it's important to recognize that what we're fighting, both in the juvenile justice bill and in the policies that I'm going to describe, we're fighting an ideological framework that still requires some pushing in order to get to deliver on things that will be important for Black people in the state of Maryland. So I'm going to go through just a few things. I'm going to start. Two of the things I'm going to start with are two items that were on LBS's legislative agenda. If you follow us, you look at our website, you look at our social media posts. I think it's a pinned post both on our Twitter and Instagram. You'll see our legislative agenda. And on it, we're getting rid of the criminal penalties for possession of recreational cannabis above 2.5 ounces. So the way the law is currently written is that the civil limit between 0 and 1.5 is the legal limit to possess. Then there's the civil limit, which is 1.5 to 2.5 ounces. And then that gets a civil citation. And then from 2.5 and above, those still are subject to criminal penalties. And we've argued this session and the previous Maryland General Assembly that given the fact that recreational cannabis is now a legal substance, that having those criminal penalties for the 2.5 above the 2.5 limit still exposes Black people disproportionately to the potential of criminal prosecution. Now, this isn't something that we're seeing, right, in terms of data that we receive that say that this is happening. The industry is still young. But if you're familiar with the way the criminal justice system works, you talk to people who are criminal defense attorneys, any chance that a prosecutor or law enforcement can add a charge provides more leverage for the prosecutors to be able to hang time over folks' head. So while we may not be seeing this as something that folks are getting convicted for, we argue that the criminal penalty, exposing people to those criminal penalties, provides additional tools for prosecutors to use as leverage, and that leverage then is used as a way to expand the amount of time that a defendant has. And we know the system operates very much on plea bargains. Most of the I think it's about 90% of cases are adjudicated by plea bargain. So with a legal substance that now people are free to use, this penalty, this criminal penalty, is an opportunity to be weaponized, particularly against Black people, from which cannabis prohibition policies have been overwhelmingly targeted at in terms of our exposure to the criminal justice system. This is a bill that was introduced, sponsored by Senator Joe Carter in the Senate, Delegate Deborah Davis in the House. It's a bill that, quite frankly, we didn't expect to move very much. I think as the new industry takes off, as we see potential challenges that may emerge, there may be a recognition that this is something that needs to move. This is something that, again, is not likely to pass this session. But again, just wanted to give an update on that. And then additionally, what you also saw on our legislative agenda is providing the ability for jurisdictions to give their police accountability boards independent investigatory power. So if you remember, I mentioned the 2021 Police Accountability Act that reformed, that repealed the Maryland Law Enforcement Officer Bill of Rights. And then what it did was it instituted a new framework for disciplinary action for law enforcement. And one of the things that it required was the establishment of police accountability boards in each jurisdiction. That police accountability board is essentially the portal by which the community gets access to the disciplinary process. Is their window into the disciplinary process. And so Police Accountability Board, for instance, it is able to appoint folks to serve on the charging committee, and it has a variety of other functions. One of the functions it holds is that the community can file complaints against law enforcement and submit those to the Police Accountability Board. The problem is that Internal Affairs, which is now called the Police Integrity Bureau, is that the Police Accountability Board is dependent on the Police Integrity Bureau. I'm going to say Internal Affairs because that, for most people, that'll make sense when I'm talking about when I say it. That Internal Affairs essentially controls the investigation. And so when Internal Affairs, the police department's staff that it hires to do those investigations, when it controls investigations, even though it is required that those investigations go the Administrative Charger Committee for them to assess whether discipline is warranted, the challenge is that those that are controlling the investigation are able to manipulate it potentially in a way that the Charger Committee would not be able to catch. And so the purpose of providing jurisdictions who want it the capacity to give their Police Accountability Board independent investigatory powers allows the community to be able to have an arm of investigation that is accountable to it, as opposed to relying on an internal investigation that is accountable to the police department. And I noticed in the hearing when this was heard, particularly the Republicans and actually one of the Democrats on the committee, on the Senate side in particular, pushed back heavily. I think there continues to be this notion that folks are offended by the idea that the community should oversee law enforcement, that the community, and there's this idea that, and all people that serve, whether it's the Charge Committee or Police Accountability Boards, there's required training. There's the Police Training and Standards Commission that provides training for folks who are not law enforcement that serve in these bodies. And so those are that's training that is provided, but there's a belief that unless you are law enforcement, that is such a specialized industry that non-law enforcement judging them is kind of offensive to many folks' idea of how law enforcement should be assessed and judged. And just, as I've argued in much of my testimony over the years, at this point, the evidence is pretty overwhelming. When you look at the Department of Justice 2016 report, the Graham report, I believe that's 2021, whether you look at the Steptoe report of 2022, looking at Baltimore City's police department, I mean, there are various, the evidence at this point is overwhelming, the extent to which law enforcement, because of its insularity, engages in the kind of misconduct where the only solution to make sure that the community is safeguarded is more oversight by non-law enforcement, particularly the community that's being policed. This is a bill, again, that didn't move. Again, there's still implementation happening around the state in terms of police accountability boards. This is a piece of legislation that we will continue to bring to the legislature, again, in order to increase the capacity for community oversight. So those are the items that was on our legislative agenda. You also see reparations. I'm going to come back to that at the end. What I'm now going to do there, if you get our action alerts and you're on our email list, you'll see there are two other pieces of legislation that we included in making folks aware of. And so I'm going to talk about those. The first is good cause expungement. So one of the things that has been happening over many years is a recognition by the legislature that one of the challenges of the war on drugs and mass incarceration is that there are lots of people who have been sucked into the criminal justice system unjustly. So again, whether you look at the Department of Justice report, whether you look at the Gun Trace Task Force, there are all these examples where people have been exposed to criminal charges and that impeding people's ability to pursue employment. Well, expungement policy is extremely complicated. And so part of what happens is that you'll have bills that come forward to try to address a certain arena of expungement, right? So you may have legislation that looks at providing expungement for occupational licensing, right? Or expungement, as we worked on with the cannabis legalization, expungement of folks that have criminal records for possession, right, for cannabis. So there are all these different genres of expungement that have kind of been piecemeal, kind of piece by piece. And one of the challenges is, and then the unit rule, which is kind of the biggest impediment. So, if you are trying to expunge non-convictions and a unit of charges where you pled to one of those charges, then all those other charges that you were not convicted of, those you can't expunge those charges. So that's the problem with the unit rule. So you have all these things that that make it difficult, that make it complex in terms of expungement policy. So Senator Carter put forward a piece of legislation, and I believe this is also cross-filed by Delegate Ruff, a piece of legislation that essentially would allow a person to petition the court to have a judge make a determination as to whether or not a person's record be expunged. So what this does is it cuts through the complexity of, is this a misdemeanor? Is this a felony? Is this in the category of things that can get expunged? Is it in the unit of charges? It cuts through the complexity of expungement and provides essentially a very straightforward, simple way for someone who is trying to get relief in terms of expungement to have their record expunged. And so that's a piece of legislation. Next week is crossover. So this is a moment where legislators are trying to get as many bills through one of the chambers as possible. So crossover, I think crossover is on Monday. What that means is that a bill that has not passed one chamber by crossover is officially dead. And so our hope is that this bill can make it through one of the chambers so that it has the rest of session to be able to get through the other side and through both chambers. So we just think this is an important piece of legislation. And so I think that's particularly important. And then, so that's one piece of legislation. Again, you should have received, or you will see on our social media an action alert related to that. And then in addition to that, there's a bill sponsored by Delegate Marlon Ampry in the House and Senator Nick Charles in the Senate. It is a bill that essentially protects the artistic expression of artists. And the target audience here is we're looking at hip hop lyrics. So there has been an increase in the weaponization of lyrics of an artist in a criminal proceeding. And the idea here is, given the stereotypes, the ways in which notions of Black criminality are ubiquitous in our society, there is a way that one's artistic expression, particularly in the genre of hip hop, can be weaponized against a person in a criminal proceeding. Well, now what this bill doesn't do, this bill doesn't make it so that if a person literally confesses to a crime in a song, that can't be used. What the bill says is that that in terms of introducing it into evidence, that the prosecutors have to demonstrate its relevance to the case at hand, because otherwise if a person's a hip hop artist, right, and they just play a person's lyrics, then that can be prejudicial to a jury assessing whether or not, someone, committed a crime, right? And so we think it's important, particularly when you think about Black artists. And one of, in addition to my role as Director of Public Policy, Leaders of a Beautiful Struggle, also chaired of the Board of Directors for the Black Arts and Entertainment District, Pennsylvania Avenue Black Arts and Entertainment District, which was an entity kind of birthed out of the work of Leaders of a Beautiful Struggle and many others on Pennsylvania Avenue. So we have a unique interest in the importance of making sure that particularly Black artists are not vulnerable to what we're seeing as an increase in the use of artistic expression, particularly hip hop, against those in a criminal proceeding. So you will have seen an action alert if you subscribe to our email list about that, and you'll see that on our social media. And so that's another piece of legislation that we're urging folks to get that through at least one of the chambers before the 18th, so we have the rest of session to move that piece of legislation. So just wanted to lay that out. Now, in laying out all those pieces of legislation that I described, I want to go back to what I said earlier about the ideological terrain of the Maryland General Assembly. These are pieces of legislation that should be no-brainers. If the legislature was a liberal bastion, as conservatives try to make it out to be, right? If the legislature was controlled by crazy lefties, then the pieces of legislation that I'm describing would be no-brainers. And so I make it a point to reiterate that, because even though their progress has been made, as I argued before, that organizations like LBS and many others have been able to push, particularly the House Judiciary Committee and Senate Judicial Proceedings Committee, in a direction that is more progressive, right? But even though they've moved in a direction that is more progressive, right, the fact that these are not no-brainers demonstrates that there's still a long way to go before a claim that the Maryland General Assembly is this liberal bastion is a legitimate perspective. And so in addition to particularly the last two pieces of legislation that I mentioned and the action alerts that we've sent out to get people to help us by telling your legislator and telling those committees to make sure that these bills make it through the Maryland General Assembly, it's extremely important to recognize that there's still a lot of work to be done on the legislature as a whole in terms of how it makes policy and in terms of the policy-making landscape. The last thing that I want to mention in terms of legislation, and I said that I would come back to this, is reparations. So one of the things that LBS has led on in the state of Maryland is around particularly reparations for the war on drugs. And as I've mentioned in previous podcasts, when cannabis legalization was understood it to be a political inevitability, we saw the opportunity to look at reparations for the war on drugs as laying the groundwork for a broader policy on reparations. And so we put in a piece of legislation this session that expanded on the work we did in terms of reparations for the war on drugs and the establishment of the Community Reinvestment and Repair Fund. That fund was created in 2023 when the legislature legalized recreational cannabis. 35% of the revenues from recreational cannabis goes into this fund. Each jurisdiction determines how they spend their portion of it. The guardrails is that they can't use it for law enforcement activities, can't be used to supplant existing government resources or programs, has to be targeted towards communities impacted by cannabis prohibition policy. So that was the framework that was used in order to establish reparations for the war on drugs. Many jurisdictions have actually passed their version of what that would look like. In Baltimore City, we have the Baltimore Reinvestment and Reparations Commission. Prince George's County passed something, Restoration and Reinvestment Commission. It's our understanding that Montgomery County is on its way to passing something similar. So jurisdictions around the state are setting up their framework for how these resources are spent. And our perspective is that when it comes to reparations, there are two questions that typically people don't have good answers to that we feel like we've been able to provide solid answers to. Those questions include how much and how do we determine where the resources are spent? Starting with the second one last, for us, one of the key aspects of reparations that gets left out, because what we hear, and there's a confusion that people have between investing in social programs versus reparations. We're clear that reparations is a demand that emerges from the revolutionary Pan-African nationalist tradition, those that are pursuing calls for sovereignty for people of African descent. What has happened is reparations, as it has become absorbed into the mainstream, what we're seeing is that everything is being called reparations, right? Investing in more education, investing in more healthcare, all these things are now being roped in, right, or looped into what reparations is. But an important aspect, and there's a conversation I had with Dr. Ray Wimbush of the Urban Research Institute for Urban Research at Morgan State University, who's one of the most renowned scholars on reparations in the country. One of the conversations I had with him is that one of the things that's most important that's being left out of the conversation of reparations is the concept of community control. Right? It's important that the community have control over the resources that are invested in Black people. And so one of the things that's important is building the infrastructure for Black people to practice control over the allocation of these resources. And so we feel that with the Community Repair and Reinvestment Fund, it has created a framework. Now, there is no perfect circumstance, because when you talk about community control, you can't legislate it, right? So we have to think about what gives the community the maximum capacity to be able to impact the distribution of resources. And we argue that the most public accessible apparatus is the local councils, right, in the jurisdictions around the state, that I'm more able to impact my council person, impact whether they win or lose their race, than I am, a state representative or a person elected citywide or a person elected statewide. And so with this theory around community control, we believe that we've answered the question, well, how do you determine how the resources are spent? You allow jurisdictions the ability to determine where those resources are spent based on their needs, with the underlying importance of making sure that the community has the infrastructure to practice that kind of control over the distribution of those resources. And so we introduced, Senator Carter being the sponsor of the Maryland Reparations Act, a bill that would have expanded, that would have changed the tax code, borrowing heavily from the Maryland Center for Economic Policy, particularly around changes in the income tax, additional taxes on capital gains, additional tax, it changed to the estate tax. So these are policies that will produce more revenues, and that these revenues will go in to this Community Repair and Reinvestment Fund, and it will be in perpetuity, right? And that these resources will be invested in Black people's capacity to practice control over these resources, to do the actual repair that is in the word reparations, that reparations is alluding to. Again, that we don't expect to move. We do expect at some point soon, the Legislative Black Caucus, of which Maryland has the largest Black caucus in the country, we expect the Legislative Black Caucus of Maryland to pick up reparations as a major element of its policy agenda in the very near future. So LBS will continue to advance our perspective on reparations. And one of the things that we urge people to do is we urge people to share the work that we're producing and will continue to produce on reparations, because this distinction of what reparations is and how to operationalize it, right? How to operationalize a policy on reparations that truly empowers the community. We've written significant amounts on this, and we've done numerous talks. And so we're hoping that folks continue to share our perspective, so that we can essentially help to drive whatever policy that is produced, particularly by the Black Caucus of Maryland, that LBS is positioned to be able to drive the agenda for reparations for Maryland and really be a model, because many states have attempted forms of reparative justice. But I think Maryland can be the first state to actually implement, because California has put legislation forward in terms of an agenda on reparations. Maryland can be the first state to put forward a piece of legislation on reparations that we can actually operationalize and actually see real resources come to the community. And so that's something that we're going to be continuing to push over the interim going into the 2025 Maryland General Assembly. So that's essentially it in terms of updates from Streets of the Statehouse. The next time that you hear from us on this podcast, we'll talk about ultimately what happens with the juvenile justice bill that's before the legislature. Again, check us out tomorrow in Annapolis at 1:30 at Lawyers Mall. Also, the bill around artistic expression, sponsored by Delegate Ambry and Senator Charles, and also the good cause expungement, sponsored by Delegate Ruff and Senator Carter. We'll keep you all updated, and in the next installment, we'll let you all know how that turned out in terms of those bills getting through the finish line. And then one of the things that I'll leave you with is that, it's extremely important. One of the things that makes LBS unique I mentioned our revolutionary Pan-African nationalist perspective, where we operate from a position of power and strength. And when we sent out action alerts, we've been very pleased with the responses that we've been getting, that people have been sending, their legislators, the notes that we send out in our action alerts. It makes a huge difference. It makes a huge difference in terms of pieces of legislation that are prioritized, right? When legislators see that, right, it's something that helps to provide LBS the ammunition we need in order to do the advocacy that we do. And so our theory of change is about the fact that our predominantly Black working class base is what powers the work that we do. And so this podcast is really just an opportunity for us to talk to our base about that work so that you all can help us in pursuing the advocacy agenda that we put out. And just in advance, want to thank people for continuing to support the work that we do by sending your legislators the action alerts that we send out, sharing our material on social media, and talking directly to your legislators about the work that we're pursuing. So again, I'm Davon Love, Director of Public Policy of Leaders of a Beautiful Struggle. You'll hear from us on Streets of the Statehouse one more time before session's over. Until then, have a good night.